listening to Driving Law, a podcast by Kyla Lee about all things related to the rules of the road.
Hello and welcome to another episode of Driving Law. I am Kyla Lee at Acumen Law, and with me, my co-host, Paul Doroshenko.
I'm with you from your kitchen.
Yeah, you're at my house and I'm not at my house.
Yes. So it's Friday, just after, it's 1 o'clock, and Kyla's on Salt Spring running a trial, and I've been conducting hearings in the office, and I just zipped over to your house to check on your dog. And we talked for a minute before the podcast, and you didn't even ask me about your dog.
Sorry, I'm focused on my trial.
I know, we talked about
What?
so
One track mind right now.
dog was asleep on the floor, content, no
On the
mess.
floor? That probably means he fell down.
Yeah, maybe, but he was in the middle of the floor. He just managed to pick himself up when I walked in, so sync and went outside, and now we're good to go.
Okay. Well, big driving law news this week.
Yes.
The Supreme Court of Canada has granted leave in the case of Emeruwa, which is a Saskatchewan Court of Appeal case. We've talked about it before. Interesting case. So the case is about refusal and reasonable excuse. Wow, I'm like in the midst of it. It's about reasonable excuse for refusal and also the mens rea for refusal. And what happened at trial, Mr. Emeruwa was convicted of refusing to comply with a demand. He had said he was trying his best. The judge found that it didn't really matter whether or not he was trying his best because the only um, elements the Crown must prove beyond a reasonable doubt is knowledge that a demand has been made and that the person failed to furnish a suitable sample.
Yeah.
Regardless of whether they couldn't do it because of some reason that the Crown said, collapses into the reasonable excuse analysis, as though I was trying my best is interpreted as a reasonable excuse, which it never has been. The Crown's a little sly about not letting that, point be known. But the Saskatchewan Court of Appeal did not agree with the trial level court and found that no, the mens rea has to be intention to not provide a sample where somebody's like, actually not put their or actually has put their lips on the device. Like you have to prove that because otherwise what you're doing is you're essentially creating an offense that turns an innocent person into a guilty person because they have literally no moral blameworthiness.
My issue here is, okay, great, Saskatchewan Court of Appeal figured it out. It's kind of obvious to me. I was surprised that the trial court went the way that it did because, like, the suggestion there would be that it wouldn't matter what happened after that. Like, it wouldn't matter what happened after the demand was made, really. If there was no sample obtained and no
Yeah.
matter what, like, it wouldn't matter.
The Crown would not even have to lead evidence of what happened after
Just need a
because
police
if
officer
that
say they
falls,
didn't get a
well, the,
sentence.
yeah, and if it falls to the reasonable excuse analysis, the defense burden, that's the defense burden to raise an error of reality, and then Crown has to disprove it.
Yeah. But I'm trying to figure out why the Supreme Court of Canada allowed the appeal because the Saskatchewan Court of Appeals decision could stand. And if they had disallowed the appeal, they would have been just affirming it. So what are they going to say?
No, when they don't allow an appeal, and I think this is actually an important conversation for us to have today because of what's happened with the Indigenous cases. Wow, we just tied driving law to land claims. Driving law drives the law.
Drive the law.
Pretty big stretch. No, when the Supreme Court of Canada denies leave to hear a case, it's not because they're affirming the lower court judgment or they necessarily agree with it. Remember, it's just like 3 judges that decide on leave. It's not the full panel. It's because it doesn't raise an issue of national importance, or it's not like a situation of conflicting judgments between appellate courts.
Yes. But when
There's no
you deny leave to appeal, it does have the effect of confirming that that's the law for that province for sure. And then it's highly persuasive anywhere else.
Yes, but granting leave doesn't necessarily mean that they're going to overturn the original judgment. I mean, am I optimistic? No, but it doesn't mean that. It can mean that they just want to weigh in on it. It could mean in this case, because it's important, because of the thousands of refusal prosecutions that occur across Canada every day, because of the fact that when C-51 was came into force in effect, the provision that put the burden of proof on balance of probabilities on the accused was repealed, meaning their old decision in Gillespie is no longer good law. They want to talk about like reasonable excuse and the law around that because there's some discussion about that in Emeruwa, and they can shoehorn in whatever they want because they're the Supreme Court of Canada. Um, so it could be that. It was an interesting statutory interpretation analysis. So they could be wanting to talk about statutory interpretation. Doesn't necessarily mean they're going to overturn it, but I think they
Oh. The you and I are fans of the Saskatchewan Court of Appeal, and for good reason. Usually, I guess my assumption is when they've allowed leave to appeal, they're going to do something. So they have a something has already been decided in their minds, and it almost feels like the hearing at that point is just a process that we go through, a little judicial theater. But I shouldn't be cynical like that. This is our system, and this is what we've
yeah.
got. But it will be interesting to see why they've allowed this and what they intend to do. And I'm
Yes.
assuming that they've already thought about it and they've already got a plan. So
Yeah,
the
but they still have to hear from all the parties.
what's the timeline?
Well, there's a window to file a factum. I can't remember. It's probably 30 days from leave or 60 days from leave. Um, and then there's intervener applications.
Oh, any interveners you can think of?
Mhm.
Yeah.
Mhm.
Oh, so you're nodding like you're thinking of an intervener that you're going to be involved with.
Maybe.
All right. Good. We'll see.
I wouldn't be able to answer
Intervene.
that one way or the other,
Oh, okay. All right.
you
So,
know.
yep. All righty. I won't dig. I will speculate that you're counsel for an intervener or that you've advised somebody on it, but I will only speculate.
Let's just say that when big things happen in impaired driving law, people ask me
And he's
questions.
going to.
Yeah. Yeah. Um,
The reason for that?
yeah. I don't
I
anyway,
wish they'd phoned you earlier sometimes before the big decision came out or before they went and argued it.
well, I'm too busy to take on every cause.
No, but you can also give people some advice about how they can set it up.
Yeah. Um, so
Okay.
that's the big news out of the
Interesting
Supreme
one to
Court of
follow.
Canada. Yes, one to follow. Um, but I still want to tie in the Aboriginal law angle here
Oh,
because
yeah.
there's been some misinformation being spread, and I think this is our opportunity to correct it. Some people have been saying that the Supreme Court of Canada refusing leave to appeal I think it's New Brunswick case that said that Aboriginal title can't exist over private property. It means that they're affirming that that's the law, and that means that Cowichan is going to be decided in favor of the private landowners. A, no, it doesn't. B, an appellate judgment from another province has persuasive value, but it's not binding on the BC Court of Appeal. And C, it's actually also a mischaracterization of what the New Brunswick case said. The New Brunswick case said you can have a declaration of title. You don't get title though. You get the court declares it and then it falls to the crown to fix it.
Well, wasn't it, weren't they saying that it's essentially an issue of compensation rather than, yeah. So,
Yeah. Crown pay
title.
First Nation.
So it actually, if that was the case, that would be fine too, but it's not the way it's been mischaracterized.
No, and the way the government is characterizing it is because they don't want to admit that, like, the correct way, and in fact, what the court said in Cowichan really is that they just have to pay the First Nation for the land that the private landowners now have. The end.
Yep. It's compensation.
Government pay First
Perfect.
Nation.
Your title that has been granted to you by the Crown is guaranteed to you by the Crown. It is still guaranteed to you by the Crown. The land that was stolen, in order to give it to you, even in a torrent system, you are compensating the people who the land was stolen from.
Yeah.
Your title is safe. I don't get it. I don't understand. I mean, I do get it that the conservatives and various people across this country want to foment hate, and like to use this division and to suggest that Indigenous people are somehow um, that we're all at threat because people want their land back. It's like
That's not it.
why 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 do people take such a narrow view and such a short-term thinking view is
Yep,
beyond me. The
it is.
government is gonna have to pay some people for a land that was taken from them.
Yep,
That's about it. And, I know the provincial government's not enthusiastic about it, but, that's what we do. We settle land claims.
yep, exactly. So,
So, yes,
um,
it's all tied together.
moving on.
Yes.
We have a big piece of legislation that is passed third reading in BC. Well, I say a big piece of legislation, but it's actually a very small piece of legislation with a big impact.
Well, big impact for a certain group of people.
Yes, so this is Bill M. I want to say M226, but I don't think that's right. I think that's the bill I don't like. Um, Anyway, it doesn't matter what the bill number is. It is a private member's bill that passed unanimous support in the legislature, which is crazy. Um,
I wrote a LinkedIn article recently about private members' bills and why they usually don't pass.
yeah. Well, this one, it seems like the thing that the government can get behind because all it does is make it mandatory for commercial drivers, as defined in the Commercial Vehicle Act, to install dash cams in their vehicles that are running and not obstructed, facing out, forward facing. So, I've been approached by a number of people in the trucking industry who are concerned about it because they're worried the bill doesn't answer a lot of questions. It actually has the one thing that I don't like about it is there's broad regulation making power. It literally says that the lieutenant governor and council can make any regulations as required under Section 41 of the Interpretation Act, which is a section of the Interpretation Act that allows the lieutenant governor and council to regulate anything to
So
fulfill a statute's purpose. Yeah. So everything's left to regulation, and the NDP government's going to support that because the government of the day, they get to make the rules.
government loves it being left to regulation because it's no debate. They write it. Some staffer writes what they want. They hand it over. The governor and council approves it, which is nobody. And then it goes to goes signed, and it becomes basically law and a regulation without any debate.
Yeah. Or study.
Yeah, and people don't know that this is how it works in this country. We have legislation, we debate that, although most of the people debating it don't seem to know what the effect is or the purpose behind it or how it's going to play out because they don't seem to make much consultation these days. And then they write in that everything will be facilitated by regulation, and none of that is debated, and it just passed, and that's the way we're regulated.
Yep. It's concerning, but I think the big questions that arise out of this are what are the search powers going to be for police if they arrive at an accident scene and the dash cam is available? One would assume because they have broad powers stemming out of the Motor Vehicle Act and commercial vehicle safety legislation that they can just take it. I'm almost 100% certain that there is a provision that allows them already to seize things when it's a commercial vehicle because of the reduced expectation of privacy. You're in a highly regulated activity and a highly regulated type of vehicle within that highly regulated activity performing a commercial purpose where you have a reduced expectation of privacy because it's not your personal purpose.
I think they still may be getting warrants in circumstances where they're concerned about criminal investigations, but I think they can just seize it for the investigation purpose of the accident itself
Mhm.
before they've even moved on to a criminal investigation for it. Then it's in their possession, it's safe in their possession. As soon as they move to a criminal investigation, all of those other criminal protections, I think, will continue to exist.
Yeah. The other question arises of like, what happens if it stops working and you don't know? Is it going to be something that you have to check on your pre-trip inspection?
Even if you check on your pre-trip inspection, doesn't mean that it continued to work the entire time.
Yeah, no kidding. So there's that. There's also, if it captures audio, it's capturing private conversations of the people in the vehicle. Like forward facing was on purpose in the debates. They talked about it being forward facing because they wanted to protect that privacy concern that people have. They don't want, workplace surveillance essentially. But if it's got audio, then it is workplace surveillance. Oh, hi, Wrigley.
Yeah. Yeah, it's supposed to be forward facing. Kind of sort of defeats the investigatory purpose of determining whether the driver was on their cell phone, um, texting or what have you. Um, it would be excellent for accident reconstruction. That can be the only legitimate purpose I can see behind this.
ICBC determinations of fault.
Yeah, that's the same thing, basically.
It could also be important for CVSE has broader powers to suspend commercial licenses and fleets as well, and they can do it not just on the basis of like carrier points. They can do it on the basis of other information.
Yeah.
So that could also be a purpose. But
Well,
yet, what are they going to
there
do?
will
Just
there will
all
be
check dash cams?
there will be purposes that end up being different purposes than the ones anticipated, as is oft or expressed, as is often the case. And maybe somebody else has some less forthright purposes that we'll find out down the road. But
Yeah.
as you know, and I know, police will find ways around even limits that are placed on it. So,
The other thing that I think poses a bit of a wrinkle in it is to the extent that maybe the police can or can't need to get warrants to get the cameras. Um, the legislation says that the owner of the vehicle or the lessee, if it is a leased vehicle, must be the one to install the camera. So if you're driving somebody else's vehicle in a commercial driving capacity, which often happens with fleets and things like that, um, you probably don't have standing to assert a privacy interest in the contents of the video camera. Because if it's only facing out the front window, it's not capturing anything that wouldn't be seen by some random person standing on the street at the same time. And the camera belongs to somebody else, so you don't have that same level of control over it. Um, I don't know. I think there might be like problems with standing and some challenges to searches of them.
is there written into the legislation? I haven't read it. Is there anything there with respect to how long it has to capture?
Nope. And there's no provisions on like whether it can be continuously recording or
So if you put in a 16 megabyte um, card in that thing that might record over in 40 seconds.
yeah.
We have one in our distillery van. We've got a front facing camera. I have no idea how to get the video, but I know it syncs with my phone by Bluetooth, um, which or our network it uses wireless, the Wi-Fi,
Oh, okay.
strangely. And I have no idea how to get it off. I suppose I could take the memory card out and I could probably view it in some format. But who's to say that I didn't put in a 16 gigabyte card that records over in 30 seconds?
Yeah. I mean,
Like
the
without some
reasons
specifications there, it doesn't actually provide much, which actually sort of would potentially undermine any attempt to get a warrant. Because how do you know there's anything on there?
that's true. Yeah. I mean, I'm assuming they're gonna have to write regulations about this because
Yeah.
otherwise it's gonna be like it's a pointless law. It's toothless.
If it doesn't hold 30 minutes worth of
There's
video,
also there's also no offense created for not doing it, which to me is wild. Like, um,
you
what?
could write $109 fine or something into the regulations.
No, you can't write an offense into regulations, can you?
You're darn right you can. Think about all of those display your N and things like that that are fall under regulation.
Well, display your N is yeah.
Remember, you plead people guilty to regulatory offenses
BAR
all the time.
30.011. Yeah, okay.
So yeah, absolutely.
Yeah.
It doesn't lead to demerits, I don't think, when it's under the regulations, does it? No.
No. But, I mean, why not just write the offense in the legislation?
Well, because it's a private member's bill.
Right. Right.
So
Not Timothy, who's a careful drafter of the law.
we shall see.
All right. Let's move on to, speaking of commercial drivers,
the ridiculous driver of the week.
this is somebody who you would want to see the dash cam from this vehicle.
Absolutely. And, it's so funny because every once in a while in winter, we're going, oh, there's so many ridiculous drivers, but we've actually struggled to find one that was good because, the action is low in winter. But as soon as this starts to warm up, we've got just so many ridiculous drivers to choose from. There was a terrible driver in a Jeep a little while back threatening everybody in Vancouver. But the one you're referring to is the school bus in Ontario. So, school bus driver driving double the speed limit with kids in the school bus. Speed limit's 50, driving 100.
That's wild.
Pulled over, charged with a female driver. Pulled over, charged with stunt driving. Probably some speeding offense as well. I don't know about the Ontario stunt driving provisions. And refusing to present her driver's license. Quite a surprise. I saw this on TikTok. It was reported, I think, on CTV. Yeah, on CTV, and it shows the back. It's one of those smaller school buses. But yeah, school bus driver driving double the speed limit, charged with stunt driving, then refuses to present their driver's license. Talk about obligations of a professional driver. School bus with kids.
Yeah,
Um,
wild.
Not unusual for us to see someone chastised by the police because they've had their child in the car and they were issued a ticket. Well, this is, school buses are not exactly the responsive performance vehicles that can stop on a dime. You can't stop that fast when you got a pile of kids in the back, normally not seat belted in school buses. Yeah, pretty bad.
Yep.
Pretty ridiculous.
Yeah, well, that's our podcast.
Yeah.
I've got to get back to court. But if you drove your school bus 50 kilometers an hour over the speed limit, you can give us a call. I don't know. Do I want that case?
Well,
There's no winning. We will deal with it. Or if you have any other driving law related issue, you can find us online at vancouvercriminallaw.com or give us a call at 604-685-8889 and tune in next week for another exciting episode of Driving Law.